Members, good morning. We have a quorum, so I call this meeting to order. Let's invite the administration to come in first. Thank you for coming. Item 1, meeting with the administration. We have a list of follow-up actions arising from the last meeting. And in light of this list, the administration has also prepared a response that CB bracket 1449/2025 bracket 02. 01 is the list. Now, would the administration please walk us through this paper? Members, if you have questions, please press the button to indicate so. So that we can clear the policy issues before we move on to the clause-by-clause scrutiny. Deputy Secretary. Thank you, Chair. Good morning, Chair and members. Now, the list provides a number of items for follow-up, namely A to J. From A to H, we are considering these with the Hong Kong Monetary Authority. Before the next meeting of the Bills Committee on the 1st of April, we will provide a response to these points, as we need to more carefully consider these policy issues and how the bill dovetails with other pieces of legislation. As for two other straightforward points in I and J, they involve some textual amendments, and we've agreed in our written response to move committee stage amendments to make these drafting improvements. At the next meeting on the 1st of April, we also we will also be proposing some committee stage amendments. Any questions from the floor? If not, then I have a question. At the previous meetings, we had questions about the SVF, stored value facilities, the thresholds, and exemption criteria. So in terms of the application procedures, thresholds relating to SVFs, has the administration come up with some new thinking? Chair, we heard members' views. In fact, we, along with the Monetary Authority, keep all options open. Perhaps I'll give the floor to the Hong Kong MA representative now. Thank you, Chair. Thank you, Francis. As Francis said, we responded to the relevant issues. Last year, we conducted consultation. We also received feedback from the market, and we started to consider the different scenarios for using stablecoins. And last year, we also commenced the operation of a sandbox. Now, we've noticed a number of things. First, only a few jurisdictions have enacted legislation on stablecoins. For these use cases, they are still at the teething stage. At the same time, we have noticed an emerging trend worldwide, and we also find some opportunities in Hong Kong. So, upon internal deliberations, we are of the view that, first of all, we should keep an open mind about including SVF's license in the permit overall mechanism. We will also be amending the explanatory notes, supervisory guidelines, and licensing conditions of the payment system and store value facility ordinance to make sure that only with express permission of the monetary authority can an SPF licensee commence operation. So we want to repeat and make it clear that the SVF operator can only start its business with express and advance permission from the monetary authority so as to balance risk and market development. So that's all from me. All right, if there are no other questions, we will continue with the clause-by-clause scrutiny. We finish at clause 121. And we'll start with 122. Now it's C3454 of the Blue Bill. Clause 122, incriminating evidence. A person is not excused from complying with the requirement imposed on the person by an investigator only on the ground to do so might tend to incriminate the persons. That means the person should provide relevant records and documents upon request for investigation, and that this person is not excused from complying this requirement on the ground that to do so may incriminate him. And then subsection 3, as explained under section 11713 of 4, if the person is required by an investigator to answer or respond to a question, the requirement and the following are not admissible in evidence against a person in criminal proceedings before any court. A, the question and answer or response. B, the explanation or particulars. Clause 123. Lien claimed on record or document. If a person claims a lien on a record or document in the person's possession that is required to be produced under this part, then the lien does not affect the requirement to produce the record or document. B, no fees are payable in relation to the production. And C, the production does not affect the lien. Clause 124, issue of magistrate's warrant. On information on oath laid by a person specified in subsection 2, a magistrate may, if satisfied that the condition is in subsection 3 is met, issue a warrant authorizing a person, police officer, or anyone as may be necessary to assist in executing the warrant to enter the premises specified in the information at any time within the period of 7 days beginning on the date of the warrant, and to enter, if necessary, by force. The person specified or the police officer may also search for, seize, and remove a record or document. Clause 125, powers of persons authorized by warrant and related offences. Now, for the authorized person under a warrant issued under 1241, if he has reasonable cause to believe that a person found on the premises is employed, engaged to provide a service in connection with a business that is or has been carried on the premises, the authorized person may require that person to produce for examination a record or document that A, is in the possession of that person, B, the authorized person has reasonable cause to believe that may be required to be produced. Clause 126, record or document removed under warrant. A record or document removed under a warrant issued under 124 may be retained after the record or document has been removed for a period not exceeding 6 months from removal. If criminal proceedings or any proceedings under this ordinance are involved, the record or document may be kept for a longer period required. Ms. Carmen Khan. I have a question on offense and the penalty. 125 subsection 4. Which piece of legislation have you made reference to? May I understand your rationale of pitching the penalty at this level? Thank you, Ms. Carmen Khan, for the question. We've made reference to PSSFO, the Payment System and Stored Value Facility Ordinance, namely 33K. That's the penalty section. In section 33K, similar offenses are provided. So we use that section as reference. Any follow-up, Carmen? No? Continuing with 1262, for the record or document obtained under a warrant, a receipt should be given to the person in possession of the record. 127, production of information in information system. Now, if there is any information contained in a record of document required to be produced, then this section applies. That is, if the information can be reproduced in a legible form, a power to require the production of the information in a legible form. If the information is recorded in a system, a power to require the production of that recording in a form that enables the information to be reproduced in a legible form. Clause 128, inspection of record or document seized. If the investigator has not obtained the record or document with authority under the section, then the investigator must permit the person who would be entitled to inspect the record or document, had the investigator not taken possession of it, at all reasonable times to inspect and to make copies and otherwise record details of it. Section 129, prohibition on destruction of record or document. This applies to a person who is required to produce a record or document by another person. That's requesting person, who are usually the investigator or somebody assisting the monetary authority under the Exchange Fund Ordinance or police officer. The person must not destroy, falsify, conceal, or otherwise dispose of, or cause to permit the destruction, falsification, concealment, or disposal of the record or document with intent to conceal from the requesting person or any fact or matter capable of being disclosed. Part 6. Monetary authority may impose sanctions on regulated persons. We've made reference again to the SVFO. So I will give the floor to Chris, my colleague from the Hong Kong Monetary Authority, to walk members through this part. At the last meeting and this morning, we already went through part 5, and we'll move on to the next part, and that is for regulated persons. They mean a licensee or an officer of a licensee or a designated stablecoin entity or an officer of a designated stablecoin entity. Now, for regulated persons breaching any section of the ordinance, the monetary authority may impose sanctions on them. And Part 6 sets out what sanctions may be imposed and the relevant penalties. Like Timothy and my colleague from the FSTB, we've made reference to the Payment System and Stored Value Facility Ordinance.
All right, on to Clause 132. The CEO and manager, including the stablecoin manager, regarding regulated person, designated stablecoin entity or an officer of a designated stablecoin entity. Clause 131. Monetary authority may impose sanctions on regulated person. Subsection 1. It sets out concrete descriptions. The monetary authority may impose one or more of the sanctions mentioned in subsection brackets 2 on a regulated person if the MA is satisfied that brackets A, a provision of this ordinance has been contravened by the person, B, a requirement imposed by or under this ordinance has been contravened by the person, or C, a condition attached to a license, consent, or any other instrument granted or given by the MA under this ordinance has been contravened by the person. And as we can see in B, there are concrete contents. Say in A, we have 1 and 2, whichever is greater. 1, $10 million, 10 million Hong Kong dollars, or 3 times the amount of profit gain or loss avoided by the person as a result of the contravention. Apart from financial penalty, the MA may also give the regulated person one or more of the following, say a caution, a warning, a reprimand, or an order to take the action specified in the order for remedying the contravention. Before the MA decides on the type of sanction, bracket 3 may be referred to. Say the MA must have regard to the following matters: A, the circumstances in which the contravention occurred, including the factors occasioning it; B, the seriousness of the contravention; C, if applicable, the extent of the failure by the regulated person to cooperate in an investigation relating to the contravention. And in subsection 5, it sets out under what circumstances may the MA impose a sanction mentioned in subsection 2 if the MA has issued guidelines under section 170 setting out the manner in which the MA proposes to exercise the power. Moving on to clause 132, it's about the procedural requirements for imposing sanctions. The MA must, before imposing a sanction on a regulated person under section 131 brackets 1 in respect of a contravention. Ms. Carmen Can. Thank you, Chairman. Regarding regulated persons, the MA may impose sanctions, and we are talking about the issuers of stablecoins. But other regulated persons are covered under the bill as well. Let's imagine if a person suffers a loss as a result of the act of an issuer in bracket 3F, that is C3473, the loss or the amount of any loss suffered or costs incurred by a person other than the regulated person, or loss or costs avoided by the regulated person as a result of the contravention. This is a factor at play instead of the compensation. I'd like to seek clarifications. If you have drawn reference from Cap 584, is the penalty comparable? That is referring to 131 brackets 2. Are the penalties comparable? In 131 brackets 2, the sanctions are to order the regulated person to pay a pecuniary penalty not exceeding the amount that is the greater of 1, 10 million Hong Kong dollars, or 3 times the amount of profit gain or loss avoided by the person as a result of the contravention. As a colleague mentioned, it's like issuing a banknote. Are the penalties comparable? Can the administration explain? Who will take this question? Chris? Thank you, Chairman. Thank you, Ms. Carmen Can, for the question. Indeed, we've drawn reference from Cap 584 in deciding on the penalties. The penalties under these two ordinances are comparable. We find this a favorable practice because for stablecoin issuance business, there are many offenses in relation to the issuance of such, and the offenses are very similar to those under Cap 5A4. Owing to these similarities, we need to keep the penalties consistent. The MA is empowered to impose sanctions, and we do think that we need to keep these penalties consistent or in line with one another. Like A2H, the administration said that they needed more time before getting back to us. So are we still using the same principle? That is the same principle, same risks, and so on. Take SVF as an example. For the license applicant, is the principal 10 million Hong Kong dollars? Is he or she required to hold reserve assets? Are they comparable? Are we comparing orange with orange? The sanction is 10 million Hong Kong dollars tops. For the issuers of stablecoins, if there is no reserve assets, in this case, if you use 10 million Hong Kong dollars as a cap, is it sufficient? Even if 3 times the amount exceeds 10 million Hong Kong dollars, is 10 million Hong Kong dollars the cap? What if the 3 times the amount of the profit gain is more than 10 million Hong Kong dollars? What if the issuer doesn't meet all the statutory requirements? There may not be a profit for you to calculate the amount. So how will you arrive at the figure? Chris, thank you. I'd like to point out for the calculation of the amount of sanction, 10 million Hong Kong dollars isn't the cap. In accordance with subsection 2A brackets 2, if the amount exceeds 10 million Hong Kong dollars, we will use brackets 2 as the basis, that is 3 times the amount of profit gain or loss avoided by the person as a result of the contravention. If the amount is 20 million Hong Kong dollars, then we use this figure as the cap. And we are preparing for the responses to questions A to H. We are working on these responses. And next time we'll explain why it is appropriate to draw reference from Cap 5A4. The penalties are very similar to those under the Stablecoins bill. That's exactly why we do think it is appropriate to keep the penalties in line with one another. Well, for Roman numerals 2, 3 times shouldn't refer to the loss avoided. Should it be 3 times the loss suffered by the victims? Is it more appropriate? In this case, you can calculate the amount of the loss suffered by the victim. How can you calculate the amount of the loss avoided by the person as a result of the contravention? Or is it more appropriate to calculate the amount of the loss suffered by a victim as a result of non-compliance on the part of a regulated person? Well, thank you, Ms. Carmen Can, for your question. We'll try to factor in your question in our responses to A to H. Thank you. Mr. Porter, housekeeping matter. Is there any English version of the response provided by the administration today? Any English version? Chris? Well, we don't have the English version yet. Why? Why is that? we are discussing with the administration as well. We have responded to the Chinese questions, and we will attach the English version later on. For responses A to H, I will submit the responses later on. Well, I'm not criticizing the administration. Our meetings are bilingual. People may be referring to the English version of the document. I understand it's hard work, but let's do your best to provide bilingual versions. Some practitioners in this industry are more used to reading English versions, so I hope you will provide English explanations as far as possible. Or we can have meetings not as frequently. Otherwise, it may be a difficult time for you to prepare bilingual documents. Clause 1313. The MA must have regard to the following matters, and the list of matters are reasonable. They should be factored in. But is the word must too strong? Considering in brackets 4 and 5, the words used are may. If we want to give more leeway for the administration, should we keep the modal verbs used consistent? This will allow more room of discretion for the administration. Otherwise, if you use the word must, there may be judicial reviews. You should allow the administration more room by using the word may instead of must. Well, I apologize for the documents. We just had a meeting last week. We're working on the documents. I remember Mr. Polte asking a very reasonable question last week. That is in relation to employees when the employee goes bankrupt. Does he or she need to declare to the MA? Regarding the drafting of the English text, I'd like to defer to the DOJ for comments. I told the chairman that at the next meeting on the 1st of April, we hope to reply to the panel as well as provide all the CSA we are going to propose. DOJ, thank you. Regarding the usage of may and must, the DOJ keeps an open mind, and we will be liaising with the MA. There may be corresponding adjustments. Thank you. The administration, please carry on. Thank you. Clause 132, procedural requirements for imposing sanctions. Before imposing a sanction on a regulated person, the MA must give a written notice to the regulated person stating the MA's intention to impose a sanction, as well as the ground for imposing the sanction. The MA also needs to specify in the notice a period of not less than 14 days after the day on which the notice is given. Then, the MA may consider any representation made for the purposes of paragraph B. We discussed clause 131 brackets 2A in the case of imposing a sanction, the amount determined. We liaised with the Secretariat, and we said that we would move a CSA. There's a right to appeal to the tribunal. Thank you.
133. Regulated person who is ordered under Section 13128 to pay a pecuniary penalty must pay the penalty to the monetary authority And then the time frame is within 30 days beginning on the date on which the notice is given, or with a longer period that the MA may specify in the notice. And then subsection 4, the pecuniary penalty paid or recovered must be paid into the general revenue. Clause 134. Please pause, Mr. Paul Chair. Just to double check 1331B. So the period could be longer as long as it is specified in the notice. That means the MA does not enjoy a broader discretion. Having considered some factors, the MA may decide on a time frame, or perhaps the regulated person could apply for an extension. So will you consider amending 1B so that discretion may be allowed to give a longer period of time for the regulated person to pay the fine? Tim? Thank you, Chair. We'll go back and consider whether this flexibility should be provided. If need be, we'll move CSA. Right. Do you consider that the business outlook is quite bleak at the moment then, and there may be a need to allow for time extensions? Clause 134, MA's power to take other action. Apart from the sanctions set out in 131, the MA may also, by agreement with the regulated person, take any action in respect of the person, whether in place of or in addition to the exercise of the power, under Section 131. So, when considering other action to be taken, the MA should have regard to the matters set out in subsection 3, including public interest and the interests of the holders and potential holders of any specified stable coins connected with its license. Clause 135, public notice of sanctions. Now, if the MA decides to impose a sanction on a regulated person, the MA may disclose to the public the details of the sanction imposed, the action to be taken, and the ground for doing so, and any material facts. Clause 136, application of sanctions in relation to former regulated person. For a person who was a regulated person at the time of contravention, regardless of whether the person is a regulated person at the time the power is being exercised, the MA may impose a sanction. Mr. Paul Chair. Sorry, I am not catching up yet. Sorry, I want to go back to Clause 134 and its correlation with 131 and 132. I think 134 addresses the concerns of Ms. Carmen Can, and that is whether the ceiling is limited. Because here it says that the MA may, by agreement with the regulated person, take action so and so, having regard to the public interest, the interest of holders of the stablecoin, or having regard to the public's confidence in the stablecoin payment system. And this is in fact the usual avenue in the US system, and that as long as you pay the pecuniary penalty, that you won't be held liable. So I want to know whether this means that you could exceed the ceiling set out in 131. Chris. Thank you, Chair. Thank you, Member, for the question. For Clause 134, it sets out other actions that the MA may take on top of and apart from the sanctions to be imposed, and that means the MA may enter into agreement with the regulated person. So the action may be in place of the sanction or in addition to the sanction. So that means if the MA agrees with the regulation for action to be taken to compensate the victims, for example, then or to introduce an internal control mechanism, then subject to the agreement by the MA, it could be done in place of the sanction. As to whether the pecuniary penalty can be further adjusted or the ceiling may be further adjusted, then subject to the agreement in clause 134, the answer is in the affirmative, in principle. So in principle or in reality, the pecuniary penalty may go above the maximum set out in 131 as long as the license is not suspended or revoked. So I want to know whether this is indeed the design of this bill. Do you want to give this wiggle room, or is it an accident? Because it could be 3 times the gain, or it could be 10 million maximum. Thank you, Chair. Thank you, Member. This is not just a possibility. The point is the MA must first of all agree with the regulated person about this action. And if the sanction is higher than the amount set out in 131, then we should still go by the ceiling in 131. In 134, however, it sets out the scenarios under which the MA may agree with the regulated person to do certain things, such as to take a rescue action so that the MA will not openly reprimand the regulated person, or to warn the regulated person in public. And that 134 brings a merit, and that is in terms of time frame. If certain things are done, there is no need to make further representation. Now, Chairman, I don't want to judge which one which one is the lesser devil. But as I said, well, say if you agree to do certain things that you won't face a reprimand, then that may be a double-edged sword for the regulated person or for the licensee. Is that really what you want to include in this bill? Thank you, Chair. Thank you, Member. In exercising this power in 134, the MA must not act arbitrarily. The MA must have regard to certain things. And for example, if we take a look at 3A, MA must consider the public interest and the interest of the holders or potential holders of stable coins. And only on this premise can MA enter into an agreement with the regulated person. Ms. Carmen Kan. This seems to allow bargaining to take place. The administration said that this is modeled on CAP 584. But if we take a look at subsection 3, the MA should consider the following factors. In entering into an agreement with the regulated person. Now, these factors include the regulated person being a licensee and the regulated person being a designated stablecoin entity. And you may recall that the MA may designate an overseas entity as a designated stablecoin entity. That means this entity is not incorporated in Hong Kong, or the principal place of business is not in Hong Kong. So my question is on A and B. If we take a look at B Roman 3 in particular, or if we go to C, if it's a designated stablecoin entity, then C 1, 2, 3 apply. And can you explain the rationale and how you've modeled this clause on that in the SBF ordinance? Now, Ms. Carmen Kan has made a valid point, because for 101, MA is empowered to designate some stablecoin entities as a designated stablecoin entity. Now, if we go back to Cap 1 or Clause 101, there are certain criteria that must be met before MA may designate any entity as a designated stablecoin entity. If we go to 2A of clause 101, the MA may be it may be of the opinion that the entity is or likely to become material to the monetary or financial stability of Hong Kong, and that means we need to tally the descriptions in these two clauses. Clause 137. Please wait, Mr. Ronald Chan. Thank you, Chair. Or just let him go through 137 first. My question is on why we need to add subsection 3 in clause 137. This part is to be construed accordingly. I don't understand why this bit is added particularly to this part but not other places. Right, 137, please allow me to go through this clause with members. The application of sanctions in relation to officer of entity. This section applies in the following. If either in committing the contravention the entity is aided, abetted, counselled, procured, or induced by an officer of the entity or a person purporting to act as such an officer, or is committed with a consent or connivance or an attribute or recklessness on the part of the officer. I will invite the DOJ colleague to elucidate this point. Thank you, Chair. Thank you, Member, for the question. Now, this part is to be construed accordingly. This phrase is added to clause 137 because this part relates to regulated persons, and that is in relation to clause 130, the licensee, the officer, and the designated stablecoin entity. So, in relation to aiding, abetting, counseling, procuring, with consent, connivance, recklessness, etc., this may not apply to the regulated person, but we should oversee these matters as well, and that is why for clause 137(2) it provides that the power is also exercisable against the officer or the person purporting to act as the officer. Now, if we go to 131, 132, etc., they only specify the regulated person but not the officer as set out in clause 137. So, part in subsection 3, we want to make sure that the clauses apply to this group of persons, that is the officers. That is why we need to add this part to be construed accordingly. Mr. Chan, any follow-up? Why do we need a separate subclause after this clause? Because otherwise it would seem that this applies to all clauses. Well, that is also another a valid alternative, but the focus is on regulated persons. If we add this subclause to all the clauses with regulated persons, it may be superfluous. So from the reader's perspective, this is a valid approach, but then it may not be useful in terms of drafting. It may be more concise to put subclause 3 in 137. I understand the drafting point, but from the layman's point of view, I do think that if the regulated person is not an officer of the entity, then you should add this subclause so that you make sure that the clause applies to the regulated person instead of putting this subclause in the end, because I am quite puzzled as to how this subclause applies. Anyway, I understand where the administration is coming from. It's just a drafting improvement.
主席，我想
Thank you, Ms. Carmen Khan. Let's get back to Clause 134. In relation to Cap 584, is this clause not in line with Cap 584? Because of lack of concept of stablecoin under Cap 584. Our system allows the MA well, if a stablecoin issuer markets stablecoins to Hong Kong, so what about companies not incorporated in Hong Kong? In the actual implementation of the ordinance, is there any mechanism for the MA to effect regulation? Yes, we know there is a mechanism. And for the entity incorporated or established, or for an individual who is outside Hong Kong, or an entity incorporated or is established in a place outside Hong Kong, the administration said that they were going to give us a reply. Now you would like to apply regulation to the person concerned. You have already set out the penalty, but can you really implement the penalty? Can you mete out the penalty successfully? You simply said in clauses 100 and 101, can you give us a scenario? For example, for an overseas stablecoin issuer, when the company is marketing stablecoins to us, if there is something wrong with the system, then you will sanction the company or negotiate with the company. Can you tell us what factors you have taken into account? Brackets 4. If the MA takes any action under subsection 2 in respect of a regulated person, the MA is not subject to the agreement with the regulated person obliged to comply with section 132. You mean this will allow more flexibility for you to carry out the action. So what is the purpose of 134 brackets 4? Are we up to clause 135? Have we gone through clause 135? At the stage of penalizing the issuer, is it already at a later stage of the sanction? Is the public already in the know? All right, clause 134, subsection 4. The MA is not obliged to comply with section 132. Let me first take this part of the question. In respect of a regulated person, even the regulated person doesn't comply with MA's instructions, a written notice may be given to the regulated person, and a written representation has to be submitted by the regulated person. In accordance with clause 134 brackets 4, this process can be dispensed with. This means the process will be faster. Just now, Mr. Potter already talked about this point. And on Clause 135, the MA may disclose to the public the contents of the sanction. Regarding banks or SVF, the MA announced the details online, informing the public of the details of such sanctions. Some of them may be in relation to anti-money laundering, and we do make announcements on our website. On Clause 134, Ms. Carmen Khan just now voiced her concern about expanding the clause or what other factors may be taken into account in executing the power given under Clause 134. It's an extension to Clause 131, so the MA needs to base itself on Clause 131 in imposing sanction. Is Clause 134 an additional measure? Clause 131 sets out in detail the factors that MA needs to take into account while imposing sanctions on regulated persons. Say the specified stablecoin holders' interest. But of course, we thank Mr. Potter for expressing the concern about the word must. We will go back and study this point. Thank you. Mr. Potter, I'd like to follow up on Clause 137. Regarding aiding and abetting, under the Criminal Procedures Ordinance, the principal legislation will be invoked even in the absence of reference to aiding and abetting. So what is the point in writing these down? The regulated person covers a wide scope. Let's take a look at the definition of officer. For the word purporting, when one simply says that he or she is involved in monitoring the regulated person, then he or she can be said to be purporting. Do you need to be treading ultra cautiously in order not to make any mistake? There's the concept of recklessness. In B brackets 2, so is it a reckless claim or a reckless act? Chairman, thank you, Mr. Potter. I'll take the latter half of the question first. For the first part, I'll defer to the DOJ. For the word purporting, indeed we want to cast the net wider. The phrase purporting to act will help us to catch officers. And this is indeed our policy intent. Regarding 1B2, regarding the word reckless, it is in relation to reckless act. When one contravenes any of the requirements, then one will be caught. It has nothing to do with whether one claims or not. Well, however, will recklessness also cover purporting if the legislation is drafted in such a way? Well, we will discuss with the DOJ regarding recklessness to see whether it will be taken to mean purporting. Say when one gives the name card to another person, but the person concerned isn't in employment anymore. Sometimes when the name card of an officer isn't recalled, is it a case of recklessness as well? DOJ, any supplement? Regarding the word recklessness, we'll go back and consider Mr. Porter's question seriously. I'll have to go back and study this point. Just now, member mentioned aiding and abetting. I believe Mr. Porter understands it very clearly that aiding and abetting are covered under the Criminal Procedures Ordinance, but this ordinance per se isn't the Criminal Procedures Ordinance. Well, regarding policy intent, yes, we need to cover the entity who is aiding and abetting counseling as well. Well, number one has a very wide scope. If we catch people abetting, aiding, or counseling, well, what if the persons in question are friends? It seems there are many traps about stablecoins. We want to protect public interest with the mechanism, but at the same time, do we want to promote this business? If so, we do need to strike a balance. Otherwise, people may be scared away. The net seems to be quite wide. Is Cap 584 equally strict? Counseling, inducing, these words have a very wide scope. When I say the stablecoin mechanism is very stable, then am I inducing someone else? Even if someone is interested, one may be afraid of being caught by law. Then one may be scared away from engaging in any stablecoin business. Thank you, we agree. The net shouldn't be cast too wide. Like Mr. Porter said, we shouldn't be adopting too abrasive measures. But we'd like to point out, for this part, there is a definition of regulated person, that is a licensee himself or herself, as well as the officers in the officers of the licensee. You may refer to clause 10 of the bill. Then you will have more information about promotion or advertisement. Well, maybe you can note my concern and you can go back and study this point. But this is our first impression when we go through the provisions. You may consider my view. Thank you. Next member, Ms. Carmen Khan. Thank you, Chairman. I agree with the administration on the policy intent. It doesn't cover a large number of people because the provision concerns a person purporting to act as an officer. For non-authorized institutions, director, manager, or board of directors. For authorized institution, stablecoin manager, chief executive director, or a manager. So for overseas stablecoin entities, the definition is wider. There are a number of types of definitions for the word officer. Just now, Mr. Porter mentioned the example of a name card. If it is written in such a way that the officer seems to be one from an overseas institution, I do think they should be covered as well. Earlier on, there were incidents in relation to non-stable coins. They were in relation to VA, virtual assets. We need to consider the effects of each case. We need to protect public investors. We need to help them understand the policy intent.
多謝主。
Thank you, Chair. Thank you, Ms. Carmen Khan, for her point. Well, as Ms. Carmen Khan has rightly put it, this is our policy intent. Right, please continue. Part 7, Tribunal Review. Going from 137 to Clause 147. It sets out specific matters relating to the operation of the tribunal. Clause 138, interpretation clause of some terms. Mr. Ronald Chan, right, I will invite the administration to go through this clause first. I have a question on this. 139. Establishment of tribunal and appointment of members. It sets out the title of the tribunal, Stablecoin Review Tribunal in English, or 穩定幣複核審裁處 in Chinese. Subclause 2, it sets out the composition. The tribunal is to consist of the chairperson and 2 or more panel members appointed by the FS as members of the tribunal. That means not less than 2 panel members. Subsection 3, the chief executive must, on the recommendation of the Chief Justice, appoint to be the chairperson of the tribunal a person who is a judge or deputy judge of the Court of First Instance, a former Justice of Appeal of the Court of Appeal, a former judge or deputy judge of the Court of First Instance. The Chief Executive may also appoint to the panel a person as a member of the board or tribunal. In terms of actual operation of the tribunal, we should go to Schedule 6 and we'll come to that in due course. Mr. Ronnie Chan. Chairman, I understand that for the panel member, 2 or more panel members should be appointed by the FS on recommendation of the chairperson, and there is no specific provision on the composition or the membership of the panel. Now, we just completed scrutiny of the critical infrastructure, critical computer systems bill. The protection of this critical infrastructure, and there is an appeal board, an appeal panel. The mechanism is very clear in that bill. It is said that if there should be 2 or more members to be appointed as members of the panel, then for the panel to be appointed by the chief executive, it should be not less than 4 persons, and the members may only appointed. Here, for the appeal panel of that bill, to be from at least 15 members should be appointed by the chief executive. Here, there is no mentioning on the number of members. Now, for the CI bill, There is also a specific provision on the composition. At least 2 should come from the IT sector. At least 2 should be legal professionals, and also 2 other members who should be tech neutral. That means neither of the above groups. Here, it seems that the panel for the tribunal is a bit vague. There is no mentioning of how many members should be appointed or how many members should be selected from the panel to form a tribunal. Apart from setting out the qualifications of the chairperson, who should be a judge or a former judge, what about other panel members? Should there be any qualification requirements? Well, we just completed the scrutiny of this protection of CICCS bill. I do think that we should include similar provisions to specify the qualifications of members here. Chris. Thank you, Chair, and thank you, Mr. Chan. In drafting clause 139, we made reference to cap 584, but we'll go back and take a look at the bill as mentioned by the member, and if need be, we will revise our design and propose an amendment. Mr. Paul, Chair. Or Mr. Tang Fei. Well, a similar question here. It says tribunal. So it's a body with a judicial power. It's not an administrative appeal board, right? And the chairperson is to be appointed on the recommendation of the Chief Justice. Whereas for panel members, they are to be appointed on the recommendation of the chairperson. So, can you explain the difference? Why the members' appointments are made by the FS, whereas the chairperson's appointment is made by the chief executive? Because ultimately, members or chairperson of the tribunal or panel all come from the legal background, and there is a lack of professionals with the necessary technical knowledge. Because after all, both members and the chairperson would be people with a legal background. According to subsection 4 of 139, the chief executive will appoint a panel of persons to be members of the tribunal, and that forms a selection pool for this review tribunal to be set up. And as mentioned, this review tribunal will comprise 3 persons, one of whom will be the chairperson, as mentioned, who will be recommending other members to be appointed as panel members. So as mentioned, on the recommendation of the Chief Justice, the chairperson will be appointed, and there will also be professionals, as pointed out by Mr. Ronald Chan, to be appointed as panel members for the review. Now in B, apart from chairperson, who would be a judge or a former judge, there are also 2 other panel members, and these panel members will be persons possessing professional knowledge. Mr. Paul, Chair, I'd like to follow up on this question of appointment. The chairperson to be appointed should be a judge, a deputy judge of the CFI, a former justice of appeal of the CA, or former judge or deputy judge of CFI. So that means for the justice of appeal, no incumbent JA can be appointed. Only a former judge or former justice of appeal may be appointed. So I'd like to know the rationale. Why not a former justice of the CFA? Well, of course, I understand there is a need to put things in bullet point for easy understanding, but at least you don't need to separate them into 3 subsections A, B, C. You can just put it in just one subclause. The next point is the word must. In subclause 3, the CE must, on the recommendation of the Chief Justice, appoint so and so. That means it's very restrictive. As long as the Chief Justice puts forward his recommendation, the Chief Executive must make the appointment. Or is it that at least 2 names will be provided for selection? Is it your policy stance that the Chief Executive should not be able to make his own choice? Or is it that the CE and the Chief Justice will put their heads together? Chris. Thank you, Chair. Thank you, Member, for the suggestions. We will fully consider other members' suggestions as well, such as Mr. Chan's suggestion that we make reference to the appointment of the appeal panel of the Protection of Critical Infrastructure Bill. We'll also consider Mr. Jie's suggestion and see if we should keep things flexible. Now, I just want to explain that we've made reference to Cap 584 for this clause. DS. Mr. Chair just now mentioned clause 1393B, a former Justice of Appeal of the Court of Appeal. When we go to 146, you will find something relevant, and that is to say, if there is any grievance against the ruling of the tribunal, the matter may be brought to the Court of Appeal. So this may be relevant. Yes, please continue. You also mentioned the use of the word must in subclause 3. It is indeed our policy stance that the Chief Executive must consider the Chief Justice's recommendation. So that means it's a step that the Chief Executive must go through. The Chief Executive must consult the view of the Chief Justice. And it's not the case that the CE must accept this recommendation. If that is your policy stance, you need to amend the drafting here, because one of the constructions possible on reading this clause is that the Chief Executive must, and then comma, on the recommendation of the Chief Justice. It means that the Chief Executive must appoint this person so recommended by the Chief Justice. But what you mentioned as your policy intent is that the Chief Executive must seek advice from the Chief Justice, not necessarily making the appointment as recommended. So you need to improve drafting here. And also subclause 5, excluding PO, public officer. And then it comes with an exception unless the person is a public officer only because so and so. Again, can you explain the policy intent for excluding the public officer as a panel member? Thank you, Chair. Thank you, Member, for the question. We want to exclude all public officers from being appointed as a panel member. However, if the person is appointed, then as a panel member, then this person could be construed as a public officer, and we want to rule out all public officers except these persons so appointed. I understand your point, but can you explain more clearly? For example, lawmakers, they are also public officers, because you are not using the term principal officials, you're using public officers. So to some extent, we are public officers. Even district councillors, to some extent, are public officers as construed by the court. So can you explain your policy stance here?
Thank you. Public officer, it's defined in Cap 1. So I'll see if the DOJ has anything else to add. But it's about any decision made by the MA. If one feels aggrieved, then the case may be referred to the tribunal. When the officers in the tribunal are public officers, then it may give rise to problems, and that's exactly why we want to rule out public officers. Well, we use the definition of Cap 1. Public officer means any person holding an office of emolument under the government. And that is the definition in accordance with Cap 1 of the laws of Hong Kong. Well, this is our general principle, and I'll have to go back to study your point. Tribunal isn't unique to stablecoins. There are other tribunals as well. So in general, the chairperson or the president is someone from the legal sector. There are also officers from the financial sector as well. Stablecoins are quite stablecoins have a lot to do with technologies, so we have someone from the technological sector as well. Regarding users, there is a perspective of protecting investors' rights. Just now, the MA already said, after all, the MA is an organization of the government. So all civil servants should be excluded. We've heard Mr. Ronald Chan's point. Should we make it clearer? We want to make it an administrative measure, but we've heard members' in view, and we'll go back and study this point. Mr. Porte, anything to add? No. Next member, Ms. Carmen Khan. Thank you, Chairman. I agree with Mr. Ronald Chan. I'm the chairperson of the Bills Committee on the Protection of Critical Infrastructure's Computer Systems Bill. In relation to the appeal board under the above-mentioned bill, there need to be people from the technological sector. We shouldn't compare this with Cap 5A4 PSS VFO. The RTGS system is used under Cap 5A4. However, when it comes to stablecoins, is the system used the same, or is the technology about blockchain? We may need to set out concrete requirements here. Chris? Thank you, Chairman. Thank you, Ms. Carmen Khan. We'll go back to study this point together. If appropriate, we may propose an amendment. Thank you. Mr. Ambrose Lam? Please switch on the mic for Mr. Ambrose Lam. Thank you. I'd like to follow up on Mr. Paul Che's point about public officers. Public officers have a very wide definition. I'm afraid having this definition will leave you few officers to choose. Public officers need to swear in to say that they support the basic law. All civil servants are public officers as well. I'm afraid it will be difficult for you to appoint officers if you make public officers not eligible candidates. Anything else to add? This is a very good suggestion. The clearer, the better. Thank you. Let's move on. Clause 140. Referral to tribunal for review. Subsection 1. A person who is aggrieved by a specified decision may refer the decision to the tribunal for review. In Schedule 6, we have a definition for it. There is paragraph 13. We may go to it in a moment. And the appeal must be submitted in writing. For any other decision of the MA within 30 days after the applicant receives the MA's written notice or within any further time allowed by the tribunal. The legal advisor provided suggestions, and we will move an amendment for the tribunal to suspend the execution of the notice. Clause 141, review by tribunal. The tribunal must review the specified decision and, after taking into account the ground for review, may confirm, vary, or set aside the decision, or remit the matter to the MA with any direction that the tribunal considers appropriate. In reviewing a specified decision, the tribunal must give both the applicant and the MA an opportunity to be heard. In subsection 4, a decision of the tribunal on a review is final and is not subject to appeal except on a point of law. Mr. Porte. Well, excuse me, Chairman, I'd like to ask about Clause 140, subsection 5. A referral doesn't suspend the specified decision to which the referral relates. Does it mean it cannot be suspended, or when one appeal on the grounds of the fact that one is aggrieved, then this is possible? Well, in accordance with the provision, Mr. Polte is correct. There is no mechanism in place to suspend the specified decision. We will move an amendment on this point. We will empower the tribunal to suspend the execution of the specified decision. There is no existing power, but then we will move an assessment to include this power. Mr. Tang Fei. Yes, I'd like to ask about subsection 4. A decision of the tribunal on a review is final and is not subject to appeal except on a point of law. So in the case of appeal, will the case be heard by the tribunal or the Court of Appeal? Any other practical guideline or code of practice about the appeal? Tim, thank you. Well, please refer to Clause 146. As about appealing to the Court of Appeal on a point of law, the applicant will have to file an appeal to the Court of Appeal. Thank you. Clause 142, powers of tribunal on review. On a review under Section 141, the tribunal may receive and consider any material by way of oral evidence, written statements, or documents, whether or not the material would be admissible in evidence in proceedings before a court, or in bracket C, made by written notice signed by the chairperson, require a person to attend before the tribunal to give evidence and produce any document in a person's possession relating to the subject matter of the review. May examine or cause to be examined an oath or otherwise a person attending before the tribunal and require the person to answer truthfully any question the tribunal considers relevant to the review. or J may determine the procedure to be followed for the review. Clause 143. Let's pause here, Mr. Tang Fei. Well, I want to ask about clause 142. Under 1A, by way of oral evidence and give evidence by affidavit. How are these two different? They refer to evidence as well, or testimony as well. In relation to J, may determine the procedure to be followed for the review. If this tribunal is judicial in nature, then the procedures will have to be followed for the review. So are the appeal procedures different for each case? Oral evidence and affidavit, indeed both of them are about testimony, but in relation to any effect or legal effect, I will defer to the DOJ. For J, may determine the procedure to be followed for the review. The procedures for any appeal may be different from one case to another. In schedules, chairperson of the Stablecoin Tribunal may lay down rules in relation to appeals. They may be different on a case-by-case basis. We'll give you more information in the discussion on Schedule 6. DOJ. Thank you, Chairman. Oral evidence is oral testimony, whereas affidavit is written testimony. They are different in terms of format. I'll see if the legal advisor has anything else to add. Well, however, in A, written statements. So how are they different? DS. Oral evidence, written statements, affidavit. We will go back and discuss it with the DOJ. We'll give you more information on the next occasion. Thank you, Mr. Porte. One doesn't need to swear in when one provides written statement. However, in the case of an affidavit, one will have to swear in. When one goes to the tribunal on oath, all the things said must be the truth, the whole truth. This criminal system is very clear. On the one hand, it is good to laymen if we settle the powers of the tribunal clearly. The blue bill is very thick. Everything is set out very clearly. It aims to help readers to understand the provisions clearly. So when 1A is hearsay evidence covered, in other words, one doesn't have to see or hear something in the flesh. The powers of the tribunal are very wide, or even wider than the court. That is because hearsay evidence isn't admissible in a criminal court or in a court. Otherwise, there may be criminal consequences or implications.
點先？我想問剛才問咗個點先。
邊位回應 ？Chris Tim。 多謝主席，多謝謝議員提問。咁呢個我哋
Right, thank you, Chair. Thank you, Member, for the question. This is drawn on Cap 584. This is a rather long provision for a layman to have a better understanding of the operation of the tribunal. So inevitably, we need to elaborate with a longer provision. Now we can go back and consider in terms of evidence, and in fact, if we go to 1421A, it says whether or not the material would be admissible in evidence in proceedings before a court. That means, well, we'll go back and consider whether hearsay is included. Yes, Mr. Chair. Going back to clause 1412B, any matter of fact has been established if it has been established on a balance of probabilities. So that's a civil burden. In fact, the Law Society and tribunals once considered these cases and what should be the proper standard of proof. For civil cases, as we understand, is one of balance of probabilities. For criminal cases, the standard of proof is beyond reasonable doubt. So here, apparently, it is the civil standard, but the penalties are on the high side. So I want to know whether this is your policy intent for the offense to be proved more easily. Thank you, Chris. Thank you, Chair, members. Again, we've made reference to the relevant laws and principles. Apart from Cap 584, we also made reference to the AMLO, that is Anti-Money Laundering and Counter-Terrorist Financing Ordinance. Now, in AMLO, there is a mechanism regulating VA trading platforms, and a tribunal is to be set up. And again, the standard of proof to be adopted is also a balance of probabilities. Cap 143, use of incriminating evidence given under compulsion. The evidence answer information that might tend to incriminate this person. The question answer evidence or information is not admissible in evidence against a person in any criminal proceedings before any court other than those which the person is charged in respect of the evidence answer or information, and then under 1425 for a contravention of 1423A or Part 5 of the Crimes Ordinance, and that's about perjury. Clause 144, registration and enforcement of tribunal decision. A decision of the tribunal on a review must be recorded in writing, signed by the chair, and registered in the CFI. Please pause, Mr. Paul Chair. Sorry, I want to go back a bit. 142, subclause 4. About self-incrimination. A person is not excused from complying with the order only on the ground that to do so might tend to incriminate the person. I want to put it on record that there are similar requirements in the ordinances relating to financial institutions, and that people may be compelled to give answers. Now, the general position in the criminal law is that a person is excused from not answering the question if the utterance may be self-incriminating. But there are also other ordinances, such as the Prevention of Bribery Ordinance, that is really restrictive. Here, it's very broad. It says that this person basically doesn't deserve any exemption at all. Is it your intention to adopt the highest regulatory standard? Is that what you seek to achieve? Tim? In fact, if we go to subsection 2, it says that anything provided should not be used as evidence in court, including 2A, B. Selena, anything to add? I agree with the administration. I have nothing to add. Mr. Chair, anything to add? Right, clause 145. Related offences. Subclause 1. The tribunal has the same powers as the CFI to punish for contempt. 2. For a person who, without reasonable excuse, contravenes Section 1423, the tribunal has the same powers as the CFI to punish for contempt as if it were a contempt of court. So that means the tribunal has the same powers as the CFI to punish for contempt. Clause 146, appeal to Court of Appeal. So as we reply to Mr. Tan Fei, the monetary authority may appeal to the Court of Appeal on a point of law against the decision of the review tribunal under Section 141. Dr. Tan Yueheng. Thank you, Chairman. Clause 146, appeal to Court of Appeal. The first subclause says an applicant or the MA may appeal to the CA on a point of law against the decision of the review tribunal under 141. And then 4B, remit the matter to the tribunal or the MA with any direction that the CA considers appropriate. The monetary authority is the applicant in the process, so why should it be remitted to the monetary authority itself instead of the tribunal? Well, I think it's a matter of drafting. If we go to 4B, it says remit the matter to the tribunal or the MA. So if the Court of Appeal considers appropriate to remit the matter to the MA, then it refers to the appeal made or lodged by the applicant instead. On the point of drafting, Selina, anything to add, Chairman? If it is to be remitted to the tribunal or the monetary authority, then the matter comes with a direction from the Court of Appeal. That means policy-wise, the monetary authority should follow up on a specific point, Mr. Paul Chair. Well, let me also chip in relation to Dr. Tan's question. I think this is a standard arrangement when it comes to interlocutory appeal. That is, in the middle of the appeal process, there may be some legal principles to be laid down and some guidance to be provided. Before the final determination of facts, the Court of Appeal may remit the matter to the lower courts because of a procedural error, because of the observation of a certain legal point. The issue needs to go back to the lower court for it to be fixed before the final determination of fact. So it's a fact finding ultimately by the Court of Appeal. It's not the case of drafting, it's just the conventional appeal process. Chris. Thank you, Chair. Thank you, Member, for the question. Yes, this is the correct understanding, and as mentioned by Selina, when the Court of Appeal remits a matter back to the tribunal or the MA, it will come with a direction for the MA or the tribunal to take follow-up action. Next, Ms. Carmen Khan. Chairman, it's a question for the legal advisor, perhaps. Well, it says that the tribunal's determination should be final. The decision is not appealable except on the point of law to the Court of Appeal. So is the aggrieved subject given another avenue of judicial review? Chris, to answer Ms. Khan's question, the answer is in the negative. Why? We want the tribunal to have the final say. So after determination of facts, we also consider the MA's specified directions, and that with the tribunal's ultimate determination, no further appeal should be allowed. Chairman, my question is this. The MA is not part of the government. If it's a government's decision, then it's subject to judicial review. I recently came across another bill which refers to an appeal panel or appeal board. And again, when it is said that this tribunal has the final determination of the matter, the legal advisor then asked whether there is another avenue for the aggrieved subject to lodge an appeal. The general answer is that the tribunal may determine facts as the ultimate determination, but the aggrieved subject may still lodge a judicial review administratively against the decision. So is it because the MA is not part of the government that this JR avenue is not provided? Thank you, Chair. Thank you, Member. If the decision is considered to be illegal or irrational, or if due process is not observed, then a JR may be granted. But here, the scope is much narrower, and that no further appeal may be allowed. No, I'm not referring to appeal, I'm referring to judicial review. As I understand, the grounds for JR are different from the grounds of appeal. So for all administrative decisions, basically, you can lodge a judicial review. So the answer is in the affirmative, Mr. Polche. Well, I originally shared the same view as the Department of Justice, but now I'm afraid that I might have misunderstood the situation. Is it that for judicial review, it's usually against an administrative decision on the grounds of breaching natural justice, or that insufficient consideration has been given to certain grounds, etc. And of course, these are grounds of judicial reviews. For administrative decisions, however, usually they involve not only administrative matters but also judicial matters. So even if the matter is taken to the court, you can only rely on the judicial procedure to lodge a judicial appeal. And then even if it's a administrative or procedural error at the Court of Appeal, the matter can be redressed judicially. Otherwise, there will be no end to a case if you could lodge another appeal through the administrative mechanism, such as JR. So unless it's a matter of significant public interest, such as a matter to be decided by the CFA, in fact, we should go by the conventional approach to JR. Am I correct? Any response from the DOJ? Right. Usually, if it's a judicial decision, we allow judicial appeals, whereas for an administrative decision, such as a decision decided by panel members, then JR should be the appropriate avenue. Now, is it possible for a justice of appeal to deal with the JR issue? I think we need to go back and rethink. Usually, you need to exhaust all avenues of appeal before you're allowed to launch a judicial review.
又梗係用翻
Well, one would resort to JR if the procedures are unfair, if it is at odds with natural justice, then one would have been able to file a judicial review. The appeal per se is a judicial proceeding. For very serious cases, they may be taken to the Court of Final Appeal CFA. But it doesn't affect another limb. Another limb is decided by the MA. Any errors made by the tribunal should go to the Court of Appeal as well. Otherwise, a case may go to either JR or CA and there may be confusion. For any error made by the tribunal, applicants shouldn't file a JR. Instead, applicants should go to the Court of Appeal. Anything else to add by the DOJ? We'll go back to study this point. Thank you. Next member, Ms. Carmen Khan. I suggest studying this point. The name is tribunal. However, the chairperson is a judicial officer coupled with 2 other members. Say clause 139 that concerns the appointment procedures. So are these proceedings a judicial proceeding or administrative proceeding? Probably the administration can provide a written reply after the meeting. Thank you. Let's continue. Clause 147. Power of Chief Justice to make rules. Providing for matters of justice, of procedure rather, or other matters relating to referrals for review or reviews under this part that are not provided for in this part. This part concerns Schedule 6 as well. Could members please refer to Schedule 6? Schedule 6, 1. Interpretation. That concerns the terms that would be cited and definitions are given in this section. Section 2. Tenure of chairperson and panel members. The chairperson or a panel member is to be appointed for a term not exceeding 3 years that the CE may determine at the time of appointment. The chairperson or panel member is eligible for reappointment for a further term or terms. Section 3. Fees for chairperson and tribunal members. 4. The chairperson or a tribunal member may be paid as a fee for his or her service, such amount as the CE considers appropriate. Section 4. Resignation. The chairperson or a panel member may resign from office by giving written notice to the CE. And Section 5. Removal from office. For the chairperson that the chairperson has become bankrupt, is incapacitated by physical or mental illness, or is otherwise unable or unfit to perform the functions of the chairperson. In relation to a panel member, that the panel member has become bankrupt, is incapacitated by physical or mental illness, Hold on, Mr. Ambrose Lam. I'd like to go back to Section 2, tenure of chairperson and panel members. In subsection 2, the chairperson or panel member is eligible for reappointment for a further term or terms. 3 plus 3, a total of 6 years. Can I confirm? DS. This is just to provide flexibility for us to consider the overall appointment term for a chairperson or a panel member. 6 years, an administrative arrangement. It is not a hard and fast rule. For a panel member or chairperson, there is indeed a need to appoint these officers for 6 years probably. Well, in other words, my understanding is correct. Can be longer than 6 years. Is that correct? Well, Chairperson, I thank Mr. Ambrose Lam. We maintain flexibility. We haven't yet formed a Stablecoins tribunal yet. But we'll do our level best to follow the requirement of the government. That is 6 years. In case of any need to extend the tenure of a member, we may consider in due course. Section 7, Sittings of Tribunal. Subsection 3, at a sitting, the chairperson is to preside. At least 2 tribunal members must also be present. Subject to paragraph D, a question before the tribunal is to be determined by a majority of those referred to in paragraphs A and B. A sitting must be held in public unless the tribunal, on its own motion or on the application of a party, determines that in the interests of justice, the sitting or any part of it should be held in private. Section 8, Preliminary Conferences. At any time after a specified decision has been referred to the tribunal for review, the chairperson may direct that a conference to be attended by the parties or their representatives and presided over by the chairperson is to be held for enabling the parties to prepare for the conduct for the review, assisting the tribunal to determine issues for the purpose of the review, and generally securing the just, expeditious, and economical conduct of the review. These are about the preliminary conferences. Section 9, Consent Orders. Subsection 1, at any time after a specified decision has been referred to the tribunal for review, the tribunal or chairperson may make any order that the tribunal or chairperson is entitled to make under this ordinance if the parties A. request and agree to the making of the order, and B. consent to all of the terms of the order. Section 10, Chairperson as sole member. Under special circumstances, the chairperson may determine a referral for review as a sole member of the tribunal. The circumstances are that the parties have agreed and given a written notice to the tribunal of their agreement prior to any sitting of the tribunal for the review. Section 11, Protection of Participants. Except as otherwise provided in this ordinance, the tribunal, the chairperson, or a tribunal member, and a party to any witness, solicitor, counsel, or other person involved in a review has the same privileges and immunities in respect of the review as he, she, or it would have if the review were civil proceedings before the court of first instance. Section 12, Procedures and Practice. Subject to this ordinance and any rules made under Section 147, the chairperson may determine the procedures and practice of the tribunal. Part 2. Specified decisions. The decisions are set out in Section 13 of Schedule 6. If members have no questions, hang on, Ms. Carmen Khan. Thank you, Chairman. I'd like to ask about C3609. It's about the seating of the tribunal. Well, how should I put it? It must be conducted face to face. It cannot be heard in chambers, is that correct? There needs to be a physical hearing, is that correct? And for a point of law, the chairperson will preside over the sitting alone. In other words, well, in Clause 1392B, a tribunal is made up of by more than 2 members. And we talked about whether this is a judicial proceeding or an administrative proceeding. 3D can serve as a reference. For a point of law, the chairperson is to preside over the sitting. And about the final decision of the tribunal, we also touched upon that. 3613, Section 10 of Schedule 6, the chairperson may determine a referral for review as the sole member of the tribunal. It sets out despite Section 132(2)(b), the chairperson may still determine a referral for review as the sole member of the tribunal. And this is inconsistent with subsection 3 of Section 7 of Schedule 6 on C3609. I'd like to seek clarifications. Thank you. Tim. Section 10. Under special circumstances, a chairperson may determine a referral for review as the sole member of the tribunal. There are a few conditions. The parties must agree and give a written notice. Well, I understand. But will you provide for such requirements contextually? That is, does it affect the composition of the tribunal? That is because on C3609 it is written at a sitting at least 2 tribunal members must also be present. And whether this is an administrative procedure or a judicial procedure. C3613, despite Section 139(2)(b), this is effective from the perspective of drafting, but I understand Ms. Carmen Khan's concern. One may not be aware of the provision on C3613. We'll go back and study whether we could advance the provision. Can we put it first? So a reader doesn't have to read until the very end before they know such a requirement. Let's take a break for 5 minutes.